Over the past few years, there have been significant changes in the practices and procedures used for construction contracts in the UK's civil justice system. Cases that in the past would have been heard in court are occasionally transferred to one of the ADR processes, such as adjudication or mediation, in accordance with the 1996 Housing Grants, Construction, and Regeneration Act. Despite being crucial to the reform, construction cases no longer support the current official referee court. In 1998, they moved their operations to the brand new Technology and Construction Court, TCC. A new judicial system was established. There had never been a judge seated in the official referee's court before. The TCC was updated and went into effect in 2005. The primary subjects of the TCC lawsuits are disputes involving technology and construction. People who work in the industry frequently raise technical and procedural issues in its lawsuits, which can be even more complicated than other legal issues and are frequently taken at face value. These situations involve experts from the fields of engineering, architecture, and quantity surveying. These courts frequently deal with cases involving appeals of earlier adjudication rulings. The TCC, which has offices in London, deals with most disputes. A website that can be accessed at www.justice.gov.uk may provide practitioners with useful information. These claims only serve as a few examples of the kinds of situations the TCC might run into. Professional negligence committed by accountants, engineers, architects, surveyors, and other professionals while performing their duties. Worries about the local government's obligations under the law in relation to building or land development. Tenant-landlord agreements that need to be repaired or broken. Tort disputes between neighbors, landowners, and occupiers, such as trespass, nuisance pollution, and other environmental issues, fire-related losses. Arbitrator rulings in engineering and construction disputes are appealed. As alternatives to going to court, arbitration and adjudication are popular ways to settle legal disputes involving construction and technical issues. The tribunals are chosen by the parties, and the parties' agreement is largely required for the arbitrator to have authority. Building contracts in the UK are impacted by a number of legislative acts, though these effects have only recently become noticeable. Due to the fact that historically the law of contracts has developed as a result of judicial decisions, there is currently a set of laws that apply to all construction contracts. The fundamental building block of contract law is an agreement. A contract is, more specifically, an agreement that entails obligations that may, if necessary, be upheld in court. Understanding the agreement's terms is essential. Because the words used by the two parties can be interpreted in various ways, there is a chance that they are not thinking of the same thing when they agree. The phrase, consensus ad idem, emphasizes how important it is for both parties to concur on the same idea. Simply because there is an agreement does not mean it is valid and enforceable. Under English law, a contract can only be enforced if both parties intended for it to be. An offer and acceptance serve as the foundation for a contract, which in turn serves as the basis for an agreement. For the offer and acceptance to be enforceable, in all but the simplest contracts, a condition must also be satisfied. An offer can be distinguished from a straightforward negotiating tactic. Before a contract can be established, an acceptable offer must be accepted. This is referred to as the acceptance. The offer must be unconditionally accepted, and the offeror must be notified. In addition to being established, a contract must be supported by consideration in order to be binding. This stipulation also holds true for all other contracts. The three most common types of consideration are the provision of goods or services, the payment of money, and the accomplishment of work. Form, a distinctive quality or manner of expressing agreement, is referred to by the term form. This formality establishes the binding nature of the agreement. Undue influence and duress. When someone is under duress, they are restrained or are the target of actual or threatened violence. Unenforceable contracts can be categorized as void, voidable, or unenforceable. Despite the fact that there is a contract in place, the law recognizes that there are some circumstances in which one or both parties cannot carry out the agreement. The basis of the contract, the terms of the contract, and any statements therein are some of its elements. Consumer Trading Organization Limited will host more concepts in the future.